Hello and welcome to Point One. 6 minutes of ethics a day could keep the legal malpractice claims away. Unfortunately, no guarantees. Today we're going to talk about New York State Bar Association Ethics Opinion 916 from way back in 2012. This question touches on Rule 1.7a, and it's pretty straightforward as they go. The question presented was whether an attorney may serve as a real estate broker in a transaction and be paid for that service while also offering free legal services on contract and other legal matters in the same transaction, with the disclosure that the client that those services are free, and that if the client so chooses, the client can retain separate counsel to represent them in the transaction. Jumping down to the conclusion here, the easy answer is no, and the opinion holds that a lawyer cannot offer to provide free legal services in a real estate transaction in which the lawyer is also acting and being paid as the broker, even if the lawyer-broker advises the client that they can retain separate counsel. The opinion actually doesn't present any independent facts because it's pretty straightforward, and but the opinion does go through a series of prior ethics opinions, and because this was so old, from 2012, ties those past opinions into the updated at the time, rules of professional conduct, the new New York rules. The opinion starts with a reference to opinion 752, where it holds a number of opinions of this committee have issued over the years. We've opined that certain circumstances a lawyer also engages in a non-legal business cannot provide both legal and non-legal services in the same transaction, even with the consent of the client. And so the opinion really goes right to the heart of that issue, whether legal and non-legal services can be provided together. And there's a laundry list of opinions that the opinion today references because the Bar Association has dealt with this issue. I'm not going to bother listing them. There's a ton of them. The link will be in the comments. But the rationale of the opinions is that the personal and financial interests in closing the transaction, wearing the broker hat, interferes with the attorney hat, the attorney's ability to render independent legal advice. And that rubs up against Rule 1.7a. The opinion puts it nicely. The problem primarily stems not from the fee the lawyer receives from rendering purely legal advice, but from the separate and independent financial interest of the lawyer-broker arising from compensation for the non-legal services. So it's the broker fee that the opinion sees as the problem, because the attorney has an interest in that broker fee that potentially compromises their independent judgment. In our judgment, that financial interest would create an influence that informed consent cannot relieve. The opinion goes on to note similar situations with insurance brokers and security brokers that are also lawyers and trying to combine both services. And also then touches on the sensitivities from the client. A client's natural attraction to the cost saving involved in the lawyer's proposal only fortifies our concerns. So a lawyer rendering free legal advice, whether pro bono or as an appendage to non-legal services, again, has to maintain that independent duty. And the opinion notes, the more likely a client is to want or need legal services free of charge, the more important is the protection of assuring the exercise of independent professional judgment unburdened by conflicting personal interests. So here, the opinion almost touches on a heightened ethical standard for a client that wants or needs free legal services. But I think just recognizes the sensitivities that, while this wouldn't be pro bono service, it would be, I guess, pro bono adjacent. And so there's an extra concern here that these could be particularly vulnerable clients, especially if the ethical out would be to just say, well, you can retain separate counsel. I mean, if these are people who are using this service because it comes with free legal advice, then presumably they wouldn't necessarily have the means to obtain separate independent counsel. So it's a well thought out opinion, and I think it touches on a couple of important points, even though it only deals with this very specific hypothetical and just Rule 1.7. Anytime that the lawyer has skin in the game, aside from the fees, whether it's an hourly or contingency fee for legal services, anytime there's a financial interest beyond the legal services, there's going to be issues. There's going to be concerns. And of course, not just ethical issues. I mean, there's a host of legal issues that could crop up. But I mean, that's, the second, as an attorney, the second you have an interest that's beyond providing the independent legal services, that's where, your antenna should tingle, and you should consider whether there are any ethical issues or ramifications. Kind of big picture, I think there's insurance considerations as well. It's dangerous to assume your professional liability coverage would apply, to work, broker adjacent work or non-legal service adjacent work. It probably wouldn't apply. And that's definitely something you'd want to review. You'd want to talk to your insurance about, and potentially obtain other insurance if you are going down the path of providing a legal services and non-legal services. Just to think about the coverage implications there. And then finally, this heightened standard idea for pro bono services. There's, I don't think the opinion goes that far or attempts to go that far by any means, but I do think it signals that there is, whether it's maybe it's not a professional responsibility heightened standard, but there's perhaps a moral heightened standard of responsibility here, that when you are providing free legal services, that client needs to be, the extra sensitivity needs to be extended to that client in a way that, this opinion could have read differently, and could have decided that, if you allow, if you inform the client that they can seek independent legal advice, then, that's fine. They can do that. But this opinion recognizes that not everyone can do that. And the targeted clients here would be people who are particularly vulnerable to that risk and wouldn't have that option. That's been your point one for the day. Thank you for joining me.